Ladies and gentlemen, this is the program on constitutional government, and our guest today is Greg Weiner. He's a professor at Assumption College in Worcester. He's the author of Madison's Metronome, which is a book on James Madison, the subject today, and a biography of Daniel Patrick Moynihan called American Burke, the Uncommon Liberalism of Moynihan. He graduated from University of Texas and got his PhD from Georgetown. He's also had some time working in the U.S. Senate for Senator Kerry, and he is also, and after that he worked as a speechwriter, which I think either reflects or improved his writing to the point that we see how excellent it is in his paper. He's now working on a book on judicial interpretations of James Madison, and he's going to give us a little talk today on Madison and judicial interpretation. So, Greg Weiner.
Thank you. Well, I appreciate the invitation and the turnout on what I gather is the last day before spring break. Let me say that I am part of at least a generation that is both profoundly grateful to Professor Mansfield and profoundly resentful, because every time we think we have an insight into something, he's already uncovered it and published it. So it seems like every time I try to, I publish on Machiavelli and Burke and the American founding, and most of the insights are already out there. So the paper is, as Professor Mansfield mentioned, is part of a larger book-length critique of judicial engagement, which I would define broadly as the position that the courts should be assertive in protecting individual rights rather than being deferential to legislatures, what we call the presumption of constitutionality. The essence of my critique is less constitutional than political, which is to say I think judicial engagement is hostile to politics rightly understood. The paper examines the general topic through the eyes of James Madison. Madison, I should say, is not the only framer whose views matter. I've described him elsewhere as less the father than the midwife of the Constitution. But he occupies a unique position in that he straddles both the theory of constitutional structure and the introduction and initial theorizing of the Bill of Rights. What I want to ask you to do before we proceed is to join me in two distinctions. I welcome being challenged on them, but much of what follows won't hold together if we don't attempt to make these distinctions first. The first one is this: how we make and how we evaluate political decisions are different issues. As I put it here, they operate on different axes. This matters, as we'll see in a moment, because Madison's critiques of majorities' decisions are often assumed to be criticisms of majority rule as a decision-making principle, and they are not. Second distinction: there is a fundamental distinction in Madison's thought between the problems of, one, the government abusing the people, more specifically the people's exposure to arbitrary rule. He calls that tyranny, following Montesquieu. And on the other hand, the problem of majorities abusing minorities, very, very different problems for him. This matters for a variety of reasons, but for our purposes, it is going to help us understand the relationship in his thought between the Bill of Rights and the courts. So with those two distinctions in mind, I want to jump into the twilight of his career before we move back to the beginning. So in 1821, we have the case of Cohens v. Virginia, which asserts federal appellate supremacy over state courts, at least on constitutional issues. And it resulted in, as many things did at the time, in a pamphlet war, one side of which was the Virginia judge, Spencer Roane. And Madison, he sent his critiques to Madison, who responded in the following way: I have always thought that a construction of the instrument, meaning the Constitution, ought to be favored as far as the text would warrant, which would obviate the dilemma of a judicial rencounter. There are two assumptions pregnant in the statement. One is that construing the Constitution is not the duty of the courts alone. Madison wished, on the contrary, that a construction that both preceded and precluded judicial involvement was preferable to one that necessitated it. The second is that far from being a natural or even indispensable characteristic of Republican regimes, judicial resolution of fundamental questions presented a dilemma. Madison's other writings suggest that the nature of the dilemma consists in pitting the essentially anti-Republican nature of judicial authority against the need for judicial independence. The suggestion of a dilemma illustrates Madison's commitment to republicanism and its compatibility with his theory of rights. We often see these placed at loggerheads. The traditional account is that majority rule threatens individual rights, but Madison saw no such incongruity. As we shall see, this is the case even where majorities behave abusively, what I've called the legitimacy of majority factions. There is no case of which I am aware in which Madison opposed the right of a persistent majority to prevail in a political dispute, even in cases in which Madison felt the majority was behaving unjustly. What we need to understand is that unless republicanism is inherently and irredeemably prone to the abuse of political minorities, which Madison never asserted and on the contrary refuted, it is entirely consistent, once we see them as operating on different axes, to endorse majority rule while believing majorities sometimes behave unjustly. This compatibility is most evident in many of the passages in which Madison is typically read as most hostile to the power of majorities. And I give several of these in the paper. Let me just highlight one now. In his 1785 Memorial and Remonstrance against Religious Assessments, Madison writes the following: "True it is that no other rule exists by which any question which may divide a society may ultimately be determined but the will of the majority. But it is also true that the majority may trespass on the rights of the minority." The key word is also, which separates the axes of authority and justice. Madison in this passage emphatically endorses majority rule and says majority rule can be unjust. Nothing about the one assertion undercuts the other. The key, again, was a regime that discouraged, not disallowed, unjust decisions. Yet it is striking that Madison almost never, I would come very close to saying actually never, discussed the courts in this context. He later wrote to Judge Rohn the following, quoting now, "Nor do I think that Congress, even seconded by the judicial power, can, without some great change in the character of the nation, succeed in durable violations of the rights and authorities of the states. The responsibility of one branch to the people and of the other to the legislatures of the states seem to be, in the present stage at least of our political history, an adequate barrier." The two things bear observation here. One is that the institutional architecture of Congress is alone an adequate barrier against abuse. He mentions no need for the courts here. The other is that Madison says violations of rights will not be durable. They will occur. I have elsewhere called this quantum constitutionalism. In other words, the Constitution doesn't guarantee just results in individual cases, but does generate higher and higher probabilities, increasing with the span of time considered, that rights will be protected. Later in his retirement, Madison opposed the constitutionality of the Missouri Compromise on the grounds that it placed potential new states under a disability the original ones did not face. Yet again, writing to Rohn, Madison neither denied the legitimacy of the majority's right to act, nor sought judicial recourse. On the contrary, this I think is one of the most important passages in Madison's democratic thought. He says, "What is to control Congress when backed and even pushed on by a majority of their constituents, as was the case in the late contest relative to Missouri?" And he goes on to refer to the internal improvements here. "Nothing within the pale of the Constitution," he specifies, "nothing but sound arguments and conciliatory expostulations addressed both to Congress and to their constituents." In other words, it was up to aggrieved minorities to persuade the majority of the justice of their views through Republican mechanisms, something the slowing of those mechanisms in order to encourage deliberation, would facilitate. This is precisely the point he had made in the Memorial and Remonstrance, and he made it again writing to Jefferson in 1825. "The will of the nation being omnipotent for right," he wrote, "is so for wrong also. In the will of the nation being in the majority, the minority must submit to the danger of that oppression as an evil infinitely less than the danger to the whole nation from a will independent of it. Now, this latter reference to a will independent of the nation, of the majority, and being dangerous, more dangerous than an abusive majority, sounds very much like how we discuss the Supreme Court today as a will independent of politics. Before proceeding to Madison's views of the judiciary and its role in protecting rights, we need to remind ourselves of the distinction again between abuses committed by the government against the people and those committed by the people against each other. Halfway through Federalist 51, Madison makes the distinction explicit. Quote, it is of great importance in a republic not only to guard the society against the oppression of its rulers, but to guard one part of the society against the injustice of the other part. Now, that distinction between the tyranny of the government and the abuse of majorities helps us better to understand a famous and I think much misunderstood passage in which Madison, in his speech introducing the Bill of Rights, seemed to empower the courts to give his amendments force. He says this: if they are incorporated into the Constitution, independent tribunals of justice will consider themselves in a peculiar manner the guardians of those rights. They will be an impenetrable bulwark against every assumption of power in the legislative or the executive. They will be naturally led to resist every encroachment upon rights expressly stipulated for in the Constitution by the Declaration of Rights. Note expressly, there's no mention of penumbras or anything of that nature here. The question the passage presents is less whether the courts have a role in protecting rights, because clearly they do, than against whom that authority is arrayed. The courts will be a bulwark against encroachments by the legislative or executive. In other words, a barrier for the people against the elected branches of government. This is the problem of government tyranny, not majority abuse. And the calling card of tyranny is arbitrary government. The court's role is to assure the government follows the rule of law in operating on the community. What Madison never says is that the job of the courts is to protect minorities against majorities, which was a distinct problem he felt the extended Republic thesis of Federalist 10 had solved without resort to institutions. We remember the famous concluding line in Federalist 10 that we behold a Republican remedy for the diseases most incident to Republican government. So as of early in the Federalist Papers, he feels he's solved that problem of majority abuse. Now, in his effort to encourage reasonable majorities, which I think is the backbone in many ways of his thought, a Bill of Rights, he says, might be helpful. Well, a Bill of Rights, Madison wrote, amounted to a mere, quote, paper barrier, yet as they have a tendency to impress some degree of respect for them, to establish the public opinion in their favor, and to arouse the attention of the whole community, it may be one means to control the majority from those acts to which they might otherwise be inclined. In other words, the Bill of Rights is a pedagogical device. It educates the the majority, and it facilitates appeals back to the majority itself. Robert Burke, once considered a martyr and now maligned in many circles on the legal right, was certainly no advocate of judicial engagement, but he nonetheless elucidates what he calls the Madisonian Dilemma, according to which neither majorities nor minorities could be trusted to balance popular and individual rights, and control is therefore transferred to what he calls a non-political institution, meaning the judiciary. But if this is a dilemma, it does not seem to me to be Madisonian. Madison understood some instances of majority abuse to be inevitable, but there is no instance in which he sought to resolve them by appeal to a non-political institution. On the contrary, as we have seen, his solution was appeal to the majority itself under institutional and empirical circumstances conducive to deliberation. So what was Madison's theory of constitutional interpretation? I would say the following. He was a public meaning originalist whose exegetical approach was rooted in the Philadelphia Constitution, but who nonetheless prioritized the public dimension over the original one. Moreover, he saw the meaning of the Constitution accreting from gradual precedents, including, in fact, I would say primarily those set by the elected branches, not from instantaneous and abstract proclamations of the courts. The only sense in which the judiciary was supreme for Madison was temporal, in this natural sequence of constitutional events it pronounced last. But for Madison, this was a fact, but also a problem. He famously writes in October 1788, this is after ratification but before implementation of the Constitution, he says, "In the state constitutions, and indeed in the federal one also, no provision is made for the case of a disagreement in expounding them. And as the courts are generally the last in making their decision, it results to them by refusing or not refusing to execute a law, to stamp it with its final character. This makes the Judiciary Department paramount, in fact, to the legislature, which was never intended," he writes, "and can never be proper." He'd made a suggestive remark in this regard at the Philadelphia Convention. This deals with the provision providing the judiciary with authority in all cases arising under the Constitution. And Madison says, shouldn't it just be cases of a judiciary nature? He says cases that are not of this nature should not be given to the judiciary. And the convention, very interestingly, rejects that, not because they disagree with it, but according to Madison's notes, because everybody thought that was self-evident, that the judiciary would only have cases over, jurisdiction rather, over the cases of a judiciary nature. But what does he mean by that? What he appears to mean is that cases that naturally came before the judiciary, that is, individual disputes, questions of trial procedure, and others that concerned obviously judicial issues, were the only areas in which the judiciary was supreme. Now, the result of that, of giving all three branches authority, is that the meaning of the Constitution is going to have to be what Federalist 37 calls liquidated over time, by practice over time. And Madison reflects that theory when, as president, he drops his longstanding constitutional objections to a national bank. I shouldn't say his objections per se, I should say the continued disputation over his objections. He says, continued disputation was, quote, "precluded in my judgment by repeated recognitions under various circumstances of the validity of such an institution in acts of the legislative, executive, and judicial branches of government, accompanied by indications in different modes of a concurrence of the general will of the nation." The repeated practice that had been continually endorsed could settle constitutional questions. That doesn't mean it alters constitutional meaning. The ability of the people to change the Constitution's meaning without amending it, even through sustained consensus, would pose serious problems for originalism. On such an account, for example, the New Deal regime would be rendered literally constitutional rather than merely representing a long-standing constitutional settlement. Rather, Madison's method pertained not to meaning itself, but to the manner of settling disputes over it. In other words, slowly and only on the basis of accumulated precedent. This proto-departmentalism does not yet settle the question of how he himself would interpret the instrument as a constitutional actor inside one of those branches. And his theory of constitutional meaning itself is elucidated most clearly in a speech opposing the original bank bill in 1791. And he gives us comprehensive standards of constitutional exegesis that are legal, but also, I would say, prudential. So he says, first of all, an interpretation that destroys the very characteristic of the government cannot be just. The very characteristic was that it was a government of enumerated powers. When the Constitution's meaning was clear, he continued, the consequences, whatever they may be, are to be admitted. Where doubtful, it is fairly triable by its consequences. Where the issue is controverted, the meaning of the parties to the instrument, this as opposed to the drafters of the instrument, quote, if to be collected by reasonable evidence, is a proper guide. And that's the foundation of public meaning originalism. Finally, he addresses claims that the authority for a bank was implicit. And he says this, in admitting or rejecting a constructive, meaning an implied authority, not only the degree of its word I can apparently not pronounce, incidentality to an express authority is to be regarded, but the degree of its importance also, since on this will depend the probability or improbability of its being left to construction. Now, that last standard, its importance, is particularly important because it casts constitutional questions as prudential ones. And Madison separately says that questions of policy and expedience are unsusceptible of judicial cognizance and decision. The only area, how am I doing on time?
Fine.
All right. The only area in which Madison, with reasonable consistency, held that the judiciary power was supreme was cases of disputes between state and national authority. So not laterally between the branches, sort of vertically between levels of government. Federalist 39 explains this famously. It is true that in controversies relating to the boundary between the two jurisdictions, the tribunal, which is ultimately to decide, is to be established under the general government. Madison is not entirely consistent on this point, even within the Federalist, as I explained within the paper, but he does ultimately say what I meant was in Federalist 39. Now, the reason that the dispute between the national and state governments has to be left to a tribunal is that the only alternative is what he calls an appeal to the sword. But what he never holds is that the federal judiciary is supreme over matters internal to the federal government. So in May 1821, responding again to critiques of Cohen's v. Virginia, Madison, quoting him now, regretted that the court is so much in the practice of mingling with the judgments pronounced, comments and reasonings of a scope beyond them. I always think of Justice Kennedy in this when I read this passage. And that in these there is often an apparent disposition to amplify the authorities of the Union at the expense of those of the states. The first point, he's referring to Marshall's propensity to declare the meaning of the Constitution in the abstract rather than confining himself to the immediate dispute between the parties, speaks to Madison's judicial minimalism. The court should not decide more than necessary, nor should it do so on a wider base than necessary, a point reinforced by his separate advocacy of seriatim opinions as a means of lessening the force of precedent. In other words, rather than a single opinion for the court, the judges should each pronounce their opinion, explain their reasoning individually. Corresponding with Jefferson in 1824, Madison described judicial review of federalism cases as the only alternative, again, to an appeal to the sword. The significant fact is that Madison explicitly distinguishes the federalism case from those involving separation of powers within the federal government. Quote, in the latter case, neither party being able to consummate its will without the concurrence of the other, there is a necessity on both to consult and to accommodate. It was only in the federalism case, rather, that Madison relied on judicial resolution. The alternative there was what he called a trial of strength. So the separation of powers, not the discrete power of the courts, was the solution to excesses of legislative authority. In the May 1821 letter to Judge Roane, Madison specifies that these structural and political factors will control the Congress. Well, importantly, there were ample constitutional means for keeping the judiciary in line. These included, significantly, the impeachability of justices, a device of which we've lost track. Hamilton's Federalist 81 had suggested this was a tool available for errant rulings. Madison wrote to Roane, it is not probable that the Supreme Court would be long indulged in a career of usurpation opposed to the decided opinions and policy of the legislature. Now, long here is suggestive. Like any constitutional authority, judicial power is subject to temporary but not sustained abuse. And the same is true of the Congress. In all cases, then, the majority were ultimately to prevail. Let me close with a few thoughts on why that is and why it matters, what it says about the issue of judicial engagement. One of my favorite writings of Madison's is an 1834 unaddressed letter called Majority Governments. It was apparently intended as a memorandum to work out his own views. And he's responding to the crisis of nullification, what he separately calls the nullification heresy. And responding to critiques of majority rule such as are beginning to be elucidated by the likes of Calhoun, he writes, it has been said that all government is an evil. It would be more proper to say that the necessity of any government is a misfortune. This necessity, however, exists. And the problem to be solved is not what form of government is perfect, but which of the forms is least imperfect. And here the general question between a Republican government in which the majority rule the minority and a government in which a lesser number or the least number rule the majority. He goes on to say that the vital principle of republicanism is the will of the majority. Madison's point was that the ultimate alternative to majority rule was minority rule. This is a point with which advocates of judicial engagement, and even someone like Burke, a critic of judicial engagement, must contend. We've also seen that Madison provided standards of constitutional interpretation, but did so to a legislature for its own use, that he came to believe in a Bill of Rights, but not as a legal tool for protecting minorities against majorities, that judicial supremacy was confined to cases of federalism, and even then its force came from sustained public support. And the vital point, there was no reason to believe a body exempted from accountability would be more faithful to the Constitution than one that was subject to public opinion. Now, the majority government's memo also points to the essential problem with judicial engagement, in my view, which is its hostility to political life. In its desire to elevate an unelected court to status as the supreme protector of personal rights, it sees politics as a threat to the individual rather than as a duty. William F. Buckley famously said, exempting current company, that he would rather be governed by the first 2,000 people in the Boston phone book than the first 2,000 members of the Harvard faculty. Are there 2,000 members in the Harvard?
I thought it was just, no. I don't know whether it was the faculty or just Harvard.
Might have been just Harvard. All right, fair enough. Aristotle, by contrast, had recognized the wisdom of crowds, and Burke had understood custom and tradition as the accumulation of wisdom over time. Yet judicial engagement, in the name of a technocratic and desiccated understanding of rationality that bears greater relation to the progressive aspiration to scientific legislation than to the conservative understanding of the nobility of politics, would transfer broad swaths of authority from the people over time to the first 9 members of the federal judiciary right now. It does so in the name of protecting the individual from the government, but it skips over the political community that mediates between them and the goods that can arise from it. Madison's is a genuinely Republican constitution, one that requires deliberation and settlement, but ultimately defers to public authority. What someone like Randy Barnett calls a Republican constitution, I would say is in fact a deeply anti-Republican constitution, even an individualist one. Most of all, a Madisonian approach must take account of how judges exempted from popular control should be expected to behave. The anti-federalist writer Brutus wrote, "In short, the justices of the Supreme Court are independent of the people, of the legislature, and of every power under heaven. Men placed in this situation will generally soon feel themselves independent of heaven itself." Madisonian reasoning arrives at the same conclusion given Brutus's premises. It is the premises that are questionable. For Madison, the Supreme Court was most definitely subject to the people in the legislature. The Constitution's meaning was to be worked out by an ongoing conversation between branches, with the people wielding the ultimate authority. This is not only Madisonian constitutionalism, it is constitutionalism of a genuinely Republican kind. This Republican constitutionalism is what the bulk of the framers, including Madison, not only preferred, but simply presumed. Their Constitution's legitimacy arises not from isolated individual calculation, but from our Aristotelian natures. None of us is the beast or God, in Aristotle's phrase, who can claim the strength of surviving outside the city or consented to enter its gates. We are born in political communities and exist in political communities. This was once a premise of conservatism that I would argue the legal right has forsaken. They are forsaking their originalism, at least insofar as we can ascertain it from James Madison as well. Thank you.
Oh, thanks a lot. Right, there's a challenge to conservative judicial activism, let's say. Tim.
Yeah, this is a very good paper, I thought. But I wondered whether it didn't ultimately move in the direction of criticism of the system that Madison himself set up. So you argue that Madison is defending majority rule against minority rule. And you say, well, that means we can't just be ruled by the 9 justices on the Supreme Court. But the alternative, which you sometimes call the people, is, for all intents and purposes, Congress. Well, let's say Congress and the executive.
Yes.
Well, Congress is 435 people, so I suppose it's an improvement on 9 people. Not clear that it's always more representative of the general population than the 9 members of the Supreme Court. It's not clear that, if you sat down with any one of the members of Congress, their tastes and opinions and interests would be closer to the average Bostonian than they would be to, a member of the Harvard faculty. So, to what extent does Madison provide a clear solution here? Shouldn't we be moving more in the direction, on Madisonian premises, shouldn't we be moving more in the direction of direct democracy?
Well, certainly not on the. It's a very good question. I mean, I think certainly on the premises of Federalist 10, we should not be moving toward a direct democracy because that's the key distinction he draws there. The way I would respond is it may empirically be true. I would doubt it, but it may empirically be true that the members of Congress don't reflect the views of their constituents any better than the Supreme Court does. But constitutionally, that's how we register the people's views. So I think we don't really have much of a choice within Madison's system, but to assume that the views of Congress represent the views of the people, particularly in the House, which was serving much shorter terms. Now, there's the distinct problem of if the legislature is in fact not representative of the people, and we might say retreats behind a wall and then proceeds as a body to abuse the people, then you have a different situation. But that separation of powers is supposed to take care of.
But would you really say that either the lower house or the upper house or both houses together are the people, in the sense that they're not authorized to change the Constitution? So you can't just have Congress saying, we the people, therefore we the current members of the Congress decide that there's going to be a 28th Amendment. So Madison himself does draw a distinction between the people and the people in this lesser sense of people representing.
Sure, it's Federalist. Someone will have to help me out. I think it's 53 that says there's a difference between the people and their constitutive capacity and their sort of ordinary capacity. I would say the difference essentially has to do with how long the majority has to cohere. Right? That with graver issues, constitutional issues, you need if you want to achieve a wholesale revolution, I don't mean to use the word revolution, but a wholesale transformation in the regime, you have to stick together for a much longer time, including constitutional challenges.
Just a quick thought on that, not actually a question, but it seems there's an important difference between amending the Constitution and interpreting
Yes.
the clauses. And so it's one thing for Congress to say, yeah, we're going to pass the 28th Amendment in contravention of the process of the Constitution. It's another to say, we think the Commerce Clause authorizes us to, pass a Health Care Act that requires everybody to buy health care, because that's an interpretation of a clause. So it seems like it's more reasonable to say that Congress could do that, would you say, than actually, tacking on another amendment.
Well, certainly, do you mean figuratively tacking on another amendment or
I thought you meant it more
literally, yeah.
Literally, yeah.
Well, so Congress obviously can't literally
Right.
tack on an amendment, although I think that's less of an anti-Republican process than is typically assumed, because as Martin Diamond pointed out, the majority within the states that approves the amendment only has to be a simple majority. So it's more of a requirement that a simple majority be nationally distributed than a supermajority requirement. In terms of Congress's ability to interpret its own powers, I think Madison doesn't see much of an alternative to this other than institutional arrangements that encourage the Congress to do so responsibly. Now, we can argue about whether those institutional arrangements still hold and so on and so forth. But he ultimately, I think, does not see any alternative to that. I think there are problems that arise, for example, in the way he handles the bank veto in 1815, when he says that, well, I've for 25 years I've held that this is unconstitutional, but it's not, because the people have, through all three branches of government, have said that it is, right? Because by that standard, the New Deal, which is commanded larger majorities for a much longer period of time, you would have to say the whole New Deal regime is compatible with the original Constitution. So I do think there are problems in that theory of constitutional change. I'm not sure there's a good alternative to it, but I do think there are problems there.
Yes.
You characterized Madison's constitutional theory as public meaning, constitutional interpretation, but I believe Randy Barnett also characterizes his own theory of constitutional interpretation as public meaning interpretation.
Yes.
So is then the distinction between just how they define public meaning, is that what separates your interpretation, Madison's interpretation from Randy Barnett?
No, I think
Or Keith
Barnett's-
Whittington or something like that?
No, I think I think he has Madison right on this, on the question of what public meaning
Yeah.
originalism means, which is that Madison says, look, you can't base the meaning of a constitution on the private intentions of the framers. It has to be the public understanding of the people who ratified it. That doesn't answer the question of who's doing the interpreting, right, and how who has the authority to do the interpreting, and that's where I think the divergence happens.
Bob Faulkner.
I want to come back to your last remark, in which you said there's a kind of problem in accretion of public approval, changing it. I want to put it this way, changing the meaning of the Constitution, it seems. Because at one point you distinguish between the meaning of the Constitution and what a settlement might be. And what you're suggesting is that a string of settlements then may change the meaning. And it seems to me the one difficulty is that applies to the courts. You yourself say in the paper that an accretion of public approval has given the courts this authority. And yet you want to argue against that authority on original constitutionalist grounds. So it seems to me there's a difficulty there. And let me sharpen my point by asking you, does Madison think that the Constitution is a fundamental law? That is a law which is to govern.
Which is to govern and which can't be changed by ordinary political means. Yeah, he says that explicitly, and again, the number that I'm struggling for, Federalist 53, I think, he somewhere makes a distinction between, in talking about election law, between the Constitution changeable by the Congress, and one only changeable by the people in their constitutive capacity. I think you're right that this is a problem. The one amendment, no pun intended, that I would make to it is that he says the settlements occur through all three branches of government, the people approving them through all three branches of government. Where I think, and this may be compatible with where you were going, what I think is a real problem is that we also have very long sustained consensus in favor of deference to the judiciary.
Yeah.
Right? So I think that's a real problem. Now, the nice thing about sustained consensus is it can evolve over time, but certainly Congress is not eager to reclaim its, generally speaking, there are exceptions to this, but generally speaking is not eager to reclaim its powers, and presidents have quite widely deferred to the judiciary. I think because it's a having one's cake and eating it too scenario. One can espouse a policy and then not be responsible for whether it goes into execution or not. But that, I think, is a real problem, and I'm not sure I've got a good answer to it yet. That meaning can be settled over time. Let me back up to one point. I do think there's something to a distinction between what did it mean and what have we over time understood it to mean. Where he says further disputation is precluded, in my view, by the sustained consensus. In other words, I think I say in the paper Madison drops his constitutional objections, but in a sense he doesn't. I don't think he ever felt the bank was constitutional. He simply felt that he didn't have the authority to impose that view over the settled views of the people.
Now I have one follow-up. I sympathize a lot with your remarks on republicanism and the importance of encouraging citizen initiative. I'm not sure that this broad outlook that you've described, this kind of republicanism of the people at large on constitutional issues somehow, I'm not sure that helps in the way that you suggest. In other words, what seems to be more important is limiting the reach of government, especially federal government, in regulating personal life in so many ways, and freeing up school committees, freeing up communities and such. And there the problem maybe less the authority of the courts than the new understanding of liberty and equality that leads the courts more and more to regulate private life. I give the example of hate speech, but there are many other. If you're really trying to reform the whole country in its attitudes, that would be one example. Then, in fact, that's made a huge difference.
Yeah, I would add to that the attitude toward liberty and equality that you see in the courts, I think, is reflective of a much broader what a much broader public understanding has come to be. What I take to be your main point, which is that one would want to encourage local, sort of more meaningful, concentrated political participation, I think is quite compatible with Madison. It does depend on which Madison. So within the Federalist, he at some point says there's going to be fixed rules of the Constitution, and the states will have the federal government will have no authority beyond that. And then in Federalist 46, he turns around and says, well, if the people think the federal government can do a better job at something, who's to say them no, right? So I think that's a problem in Madison's thought.
Susan Chow.
Thank you. Thank you for an extremely interesting paper. This is certainly an area in which I have no expertise, but except as maybe as an American citizen. So I wonder how Madison might have viewed the situation from a post-Civil War perspective, and maybe you could reflect a little on that, because I mean it's all very well to talk about judicial supremacy in issues of federalism and that's it, but guess what? Dred Scott didn't work out that well, and so that solution proved flawed, and the issue was ultimately settled by the sword, and given the Civil War amendments and the purpose of the Civil War amendments and the expansion of federal power that was inevitable, perhaps following the Civil War, I'm just wondering whether. One wouldn't have to, revisit a kind of presumption that one could count on separation of powers to protect the people in the long run from the incursion of government, particularly if the people includes minorities within the people. I mean, obviously, separation of powers within the individual southern states was not going to protect blacks, freed slaves. And so therefore, the courts would have to play a kind of more significant role in that respect. But I'm wondering even more generally whether, in light of post-Civil War America, if Madison were here, he wouldn't have to somehow revisit some of these prudential arguments.
Yeah.
She's an American citizen with a Harvard PhD.
Right. I'll take this carefully. First of all, I think with respect to
Manhattan phone book.
With respect to rights not being protected within the states, that's the purpose of the extended republic thesis of Federalist 10, that if you enlarge the sphere, you get a diversity of interests that are unlikely to accrete into an abusive majority. The post-Civil War, I guess there are two dimensions of that. One is the amendments, and then second is the political culture post-Civil War. Of course, during the Civil War, the Supreme Court did not prove terribly powerful because Lincoln, I think this is overstated, but to some extent Lincoln...
because we were involved in the settlement by the sword. So
Right. Madison does acknowledge that there are ultimate issues, right? And remember when he's in that passage where he says nothing within the pale of the Constitution. Right, so what he repeatedly counsels is, and he says this on the Missouri Compromise, he basically says live with it to the South. You're going to have to live with this unless you think it's so bad that it justifies the appeal to heaven, right? Which clearly he means to discourage. His final political testament to the nation is please keep the Union together. In terms of the amendments, I think the 14th Amendment in particular has been mistaken as a tool for judicial imposition. It has certainly fueled a significant expansion of federal power, but it also specifically says Congress has the power to enforce these articles by appropriate legislation. Now, there are people who zero in on that word appropriate and say, well, who's going to decide what's appropriate? That must be the role for that. That's sort of the point of entry for the courts. But I don't think on Madisonian grounds, the propriety of legislation is a prudential question. So, well, I do tend toward the view that the 14th Amendment was meant to incorporate the Bill of Rights, the first 8 amendments against the states. There's dispute about that, but I tend toward that view. I don't think Madison would view it, or its framers, by the way, Bingham and Howard, would view it as a tool necessarily just for judicial imposition.
No, I'm not so much concerned about the specific amendments as once former slaves are included as citizens whose rights have to be, who count as part of the people, which wasn't exactly fully clear prior to the Civil War. I'm just wondering whether in other words, whether a certain confidence that you could count on federal separation of powers all by itself to provide against consistent and persistent abuses of the people, either in their majoritarian or their minoritarian capacities.
Right, okay.
Whether that confidence doesn't become somewhat suspect.
I see. So, all right, thank you. So here I would say I would revert to Madison's view, which we see in Plessy, we see borne out in Plessy, that it may be that there's going to be a problem with those sorts of abuses and abuses of individuals. But the question is, why should we be any more confident in the views of an unelected court than we should be in the views of a seasoned, deliberate majority? So I suppose I'm thinking out loud, which is dangerous, particularly on camera, but I suppose one could view the 14th Amendment in a sense as a working out of the thesis of Federalist 10, that we'd rather these decisions be made at a national than at a local level. But of course, nationally, they weren't made with any more, for 80, 90 years, weren't made with much more justice. Although we do see that there are the Civil Rights Acts in 1868 and so forth.
Yes.
I'd like to make 2 observations on your theses and on Madison himself. I cannot separate out the 2, and I'd like your comment upon them. First of all, it seems to me that you ignored in your discussion of federalism the Virginia and Kentucky resolutions. And I would consider them, if I may go to an extreme, that Madison and Jefferson are themselves the fathers of nullification. And that this means that a majority of a state legislature acting in a political way can determine what the Constitution is for their constituents in their state. And that is, that did ultimately lead to the sword in the long run. And it seems to me you haven't considered that, and you haven't explained to me why and how Madison can oppose Calhoun late in life after having gone along with Jefferson, doing those 2 resolutions. So that's issue number 1. Secondly, I am not a lawyer, but it is my understanding that lawyers seek, first and foremost, to be able to tell their clients what the law will be as pronounced by a court. Jefferson too. Madison was not a practicing lawyer, and when he draws a distinction between the juridical and the constitutional, it seems to me that he fails to understand that to do the juridical, to state what a decision should be it just or unjust, and the judge has to offer a principle to guide lawyers in the advice of their clients, so that you cannot separate the juridical from the constitutional, because there will always be a maxim, separate be equal, separate cannot be equal, attached to a concrete decision. And therefore, the separation of the 2 is impossible because the juridical will always become the Constitution.
Thank you. Those are two very good points. On the Virginia and Kentucky resolutions, I definitely think there's an I think there's an inescapable inconsistency in Madison. But I will say this: the sequence of events is, as I read it, is this. Jefferson drafts the Kentucky resolutions, sends them to Madison, and Madison immediately drafts the Virginia resolutions. I think is a way to try to shove that genie back in the bottle. But you're certainly correct that Calhoun himself thought was shocked at Madison's position later. I think the Virginia resolutions, I often ask students, what does interposition mean? And they say, I don't know, and my answer is, well, I don't know either, because it's a doctrine that's wholly unclear. But it has to be contextualized by the Virginia Report of 1799 and 1800, which Madison also wrote, which was an explication of the resolution. I think somewhat of an attempt to put that genie back into the bottle. But what he says there is, no, all we were doing was trying to rouse the attention of the states, which he says in, I think it's Federalist 44, may be necessary, that we were trying to appeal, that these were appeals to public opinion. How far that gets him off the hook, I'm not sure. On the constitutional versus the juridical, I'm not a lawyer either. I suspect one thing that may help here is Madison's latent assumption, which I think is latent I actually think in Federalist 10, but in more than one place, that you have a fairly simple national government doing fairly simple things. So I suspect that Madison would say that if the law is so consistently unclear that it requires explication from the courts, you have a problem with either the drafting or perhaps the scope of the law. I might add to that I think that, and this is not quite responsive to your question, I don't think, but I think our need for constitutional certainty is unnecessary. I think the idea that we see Kennedy say this in the Casey opinion and so forth, that liberty finds no refuge in a jurisprudence of doubt. Does anybody remember? Is that the statement in Casey? I'm not sure why that's the case, that we can't have ongoing constitutional disputation. I think that speaks to a more general fear of conflict.
If I want to get my money from you and it involves a constitutional proposition, I don't want any doubt. I want my money.
Fair enough, but I think Madison's solution to that would be to confine the range of issues that become constitutional.
Time. You've talked a lot about, that's one of your great themes, the passage of time, the necessity of deliberation, the foolishness of haste. Does this take a sufficient account of emergencies that arise? This is kind of a general question. But maybe you could explain a little about your views on the metronome and the whole question of durability and so on.
Right. So the thesis of that book is that Madison sees the Constitution as a pacing mechanism, so that a majority has to be settled in order to get what it wants. I think it's a very fair question of whether it takes account of emergencies, particularly because my own view is that Madison's construction of constitutional mechanisms to account for time is such that the more serious the issue, the longer the majority has to cohere. And if you combine that with his deep skepticism of prerogative, I think that may be a problem in emergencies. I would say the one exculpatory thing I would say there is that the world is moving so much faster than he could have imagined today. But if you go back to the War of 1812, to his message to Congress asking for a declaration of war, it essentially says we're already in a war. right? The British had committed acts of war and so on and so forth. I am nonetheless submitting this to your deliberation, which was quite an uncertain outcome. And Madison is for that reason, among others, including his conduct of the war, which was quite questionable, regarded as a weak president. But I think that says something about our standards for presidents more than it does about Madison. But I do think that's a fair point. I'm tempted to give you a tautological reply if I thought I could get away with it, and say that the pacing mechanisms are sort of calibrated to the necessity of the situation, such that emergencies can be dealt with quickly. But I'm not sure I'm not sure I can defend that thesis.
In the Federalists, there are said to be two aspects of political power: stability and energy. And so was Hamilton the energy man and Madison the stability fellow?
Well,
or would you?
I think that's probably generally a fair distinction. Certainly, Hamilton was a stability person too. The Pacificus Helvidius debates help us to understand, these are 1793 and 94 help us to understand that distinction as to what energy means. I think Madison, I think the real dispute is scope of powers. Right? So I think within a power that the national government appropriately holds, Madison is all for energetic execution. I think the difference is in their debate over the scope.
Yes, Robert.
Thanks so much, Greg. It's a really interesting talk. So I guess I'm just wondering, it seems as though that, on your view, Madison believes that majorities, as they express themselves through Republican electoral institutions, are going to be more respectful of originalism, I guess, than appointed unelected judges. And is that right? And if so, like, why exactly does Madison think that? I mean, because of reasons articulated in Fed 10, or?
Well, I would amend that slightly and say he thinks they're going to be more respectful of minority rights. Okay. Right? And this goes back for me to this thesis of time as a seasoning mechanism. So, I think Madison's position is that so he says I think I didn't quote it when I spoke, but he says, it's in the paper of the treaty regarding the Mississippi in 1786, that I can never conceive it to be expedient because I can never conceive it to be just. Right? So I think he thinks something must be just to be expedient, and I think he, in his mind, because time does so much to dissipate passion and cause reason and long-term perspective to take hold, I'm not going to violate I'm going to realize it's in my own interest, unlike what Tocqueville would call self-interest rightly understood. I'm going to do I'm going to respect your rights so that you'll respect mine. I think he's counting on that to take hold. Now, he does say that this is not going to work in emergencies. This is one of the reasons he's quite skeptical of a Bill of Rights. When I say emergencies, a better word would be panics, right? Because one of his reasons against a Bill of Rights was he says it's least effective when most necessary, and all you're going to do. I compare it with students to I'm from Texas, and I don't know if this is just a Texas tradition, but holding up the paper in front of the football team when they run out. Is that all right, good. We'll just go with this. The Bill of Rights is no more powerful than that paper as a restraining mechanism when the people are whipped up into a frenzy. And one of the reasons Madison is initially skeptical of the Bill of Rights, as he's saying, is every one of those quote unquote emergencies is going to become a precedent for ordinary times.
So the striking philosophical implication of that is that your judgment is that majorities are better safeguards of natural rights, if there are such things as natural rights. Is there such thing as natural rights in Madisonian constitutional interpretation? Because as we know, some of the Jaffas of the world do assert that, and Barnett as well. But it seems to me that your project is to not deny natural rights thinking, but
No, it's-
to affirm that's better, most protected under a framework of majority rule. That is cool and refined over time.
I think that's right. I mean, there's no question there's a theory of natural rights. And he does say that the courts will be impenetrable bulwarks only for those rights explicitly specified in the Constitution. But I think the status of natural rights of the founding is I'm going to use the excuse of saying it's a whole other topic. But I do think the essential question, particularly with the Jaffa and so forth, is not who, but what process is likeliest to respect them. Right? In Madison, it's seasoned majority rule. Seasoned majority rule.
Yes.
So here we are today with more discrimination suits than ever in the history of time, sex, age, race, everything. Would Madison have said that if those were somehow, since they're inappropriate, if they were disallowed, that the legislatures would have done a better job of preventing discrimination of majorities against minorities?
I think he would, and I think there's empirical evidence that backs him up. The Brown decision, the Rosenberg's book on this, I'm persuaded by, the Brown decision in and of itself does very little to integrate schools. It's the 1964 Civil Rights Act that has real teeth behind it. So I do think he thinks legislatures are a much more effective guardian.
They should be, but they would have been too.
I think he thinks under conditions conducive to deliberation, which particularly today is a significant supposition, they are likelier to than that. In other words, there's no inherent reason to assume that 9 justices on the Supreme Court are going to do a better job of doing this than in fact, there may be reasons to believe they'll do a worse job, but on Brutus's suppositions, than a seasoned majority.
But they become the last resort.
The courts have,
Yes.
they have become, yes. Yeah.
Just on that point, it just seems very doubtful to me that if the Supreme Court hadn't somehow weighed in as a kind of pedagogical platform, that given all the other interests that would have intervened, log rolling, and we got to keep those Southern Democrats happy, and so on, that the schools would have been integrated in any time near when it happened.
Yeah,
I mean, so it means that this is a kind of hypothetical history, but the question isn't who's smarter. The question is really, for purposes of setting a kind of pedagogical tone in interpretation, are these justices less likely to be influenced by shallower political considerations, the sort that they're supposedly insulated from?
Yeah.
Could you speak to that issue?
Sure. I mean, in your description of it as a pedagogical device, I think is very apt, because I don't think Rosenberg would disagree with this, but one place in which I would amplify his thesis is that you probably don't get the '64 Civil Rights Act if you don't have the impetus of Brown first. But recall that Madison's point is, why should one inherently believe that these 9 people are going to do a better job than the rest of us?
You don't believe it, they won't play that pedagogical role.
Fair enough, but there's also the fact that for every Brown there's also a Plessy, and so there is, I think, reasonable reason to doubt that. But even Judge Jay Wilkinson of the Fourth Circuit, who is the most, I think the most committed to judicial restraint, says that Brown served a pedagogical purpose, that it got the ball rolling on civil rights.
Yes, Tim.
Thanks. Do you think there's a tension between Madison's interest in limiting the scope of the federal government, which you've emphasized, and his theory that the Constitution can be changed? I mean, whether you want to call it the meaning changed or the settlement, the constitutional settlement is changed by enduring decisions of the members of the federal government. You could call that's been approved by the people because the government, a series of congresses have made a certain decision. It's backed up by the judiciary, backed up by the executive. By definition, all of these people are members of the federal government. So it's very unlikely that they're going to be shrinking their own power, and it seems quite likely that they're going to be continually deciding that actually, yes, we do have the right to interfere in this new area. So if the Constitution can be changed by the government, how likely is it that the government is ever going to limit itself?
That there's an inherently expansionist tendency. Yeah, I think that's fair. Madison makes the case in the Federalist Papers in the 40s that the people will be more loyal to their state representatives and will therefore want those things done because they know them better and so forth. And therefore will want those sorts of things done at the local level. I've never been wholly persuaded by that, but I will say this, that in terms of, I have a whole separate paper on what Madison is assuming about minority factions, sort of interest groups in Federalist 10. And one of the things he's ultimately assuming is some restraint of public appetites. And he does say in the Virginia, I think there's a myth about Madison that he's a pure pessimist about human nature and wants to work with our, there's some of that in Federalist 51, but there's also a prevailing assumption of adequate public virtue for Republican citizenship and Republican life. So he says in the Virginia Ratifying Convention, Patrick Henry asks him why the Constitution doesn't take account of inculcating virtue. And Madison says, if there's no virtue among us, we're in a wretched situation and no theoretical checks will save us, or something to that, something close to that. So I think that may be the ultimate resort there is, and it poses a more difficult question, which is what happens to the Madisonian thesis when appetites grow.
Madison, is there a certain belief in history in Madison? That is, I had the impression long ago reading him that in both foreign affairs and also domestic affairs, he supposes that with commerce comes a kind of pacifism, peaceableness, therefore the need for something like Hamilton's emphasis upon a powerful executive, or the need for pedagogical teaching about the importance of the federal government in a country that had been up to then made up of states. Those needs are somehow slighted. Let me add one part to the last point. One reason why Marshall thought it was very important that the judges interpret the law is that they're more learned, and ours is an enlightened country, and notions of rights and constitutional government and all of that is artificial and has to put it bluntly, be spread but also imposed. And I don't see those sides in Madison, and bluntly put, is he not a somewhat optimistic sap?
Okay, well, let me see if I can rise to that challenge. I do think there are certain assumptions about progress that are built in. So he talks about, for example, the progress of roads and canals and railroads and so forth will have the effect of allowing the country to grow and so forth. I would distinguish that from an ideology of progress, right? So I don't think he's in the same vein as a Woodrow Wilson who wants to sort of shove the process of history in a certain direction. I think Madison's view is more passive. Now, with respect, but I do think you're right that there is some optimism. He says in I keep forgetting the numbers of my Federalist Papers today. It's 55 or 57 that if we're purely pessimistic, then we shouldn't believe in Republican government, right? The Republican government has to assume some capacities in the people, but also some capacities in the legislators and the political actors not to abuse their authority. I think his answer to Marshall is that the essence of constitutionalism is not to assume that what is true today will be true tomorrow. So certainly the first generation of justices, not all of them, but many of them were quite learned. The question is, what is it institutionally that guarantees that to be that will continue to be the case? And that, I think, is where Madison would be doubtful.
I wonder whether in our present situation, in which judges are really tempted to pursue on the one side a kind of progress, certainly, and in fact are ashamed of the old Constitution. I wonder in the present situation, is it politically wise to emphasize, can I put it this way, the possibility of variation in the Constitution, the possibility of changing with public moods and such? I don't think I'm doing your argument justice, okay?
Well,
but at least I want to raise that, given the present situation when both on the Trumpian side and on the Sanders side, a belief in our institutions as institutions is almost absent.
That's right. So in other words, is it, do we want to license the sort of constitutional mutability that, to which the judges are prone? I think if we, I suppose, so if we honestly understand Madison, which may be another optimistic supposition that's built in, the courts are the least important element of that mutating, I don't want to say mutated, but that sort of long-term constitutional settlement. So the bank, in which he pulls a little bit of a fast one, because the bank was certainly controverted in 1815. The idea that it was long settled, I think, is a bit of a stretch. But he says it's through all three branches of government. Now, McCullough is not until 1819. Do I have that right? So I'm not sure. It's not even clear to me what he means by judicial there. But the point is, it's all three branches ratified by the sense of the nation. So, but that, one of my problems with the theory of judicial restraint is that we don't count on any political actors to restrain their own exercise of power. We count on countervailing power. So I would not want to simply trust judges to say, well, I'm going to be humble and passive here because all three branches of government have it pronounced.
So Madison would be in favor of the establishment, properly understood. Even the swamp, because the swamp, to go through a swamp slows you down. And that's...
It's a smaller swamp.
It's part of it, and it gets you wet, and your feet are cold, and that's part of the cool and deliberate sense of the community.
It's the malaria that throws off the...
Yeah, the malaria. That's true. Yeah, and so, for Madison, haste is really the main enemy. Is that haste?
I think that's right.
Is the enemy of republicanism?
I think that's right. I think majorities that get into a rush mistake their own interests, right? And that's the key. It's not that they mistake other people's rights, it's that they mistake their own interest in obeying other people's rights. So the way I explain this to students is those who work in retail, if I go into Best Buy, the students who work in retail, if I go into Best Buy and there's the 8,000-inch 4D, whatever they're up to now, television that my wife won't let me have, that was a joke for the camera. If the person says, well, if the customer says, well, that's a really interesting television, I think I'll go home and think about it and come back tomorrow, right? The salesperson is going to start offering discounts and try to rush them into a decision because they know that the natural, it's not that they're going to go home and there's somebody whose job it is to talk them out of it. It is that the natural function of time is to dissipate passion. Passions are naturally short-lived. I think there was a question in the corner.
Yeah.
What was the first year in which we had 9 justices on the Supreme Court? I don't know the history very well and of the Supreme Court, but I do believe that the number of justices has varied somewhat.
That's up to Congress to set. I actually, someone else may be able to help here. I actually don't know when it went up to 9. I want to say during the Civil War, actually, but I may be wrong about that. I know
Civil War.
that's a vague recollection, so I may be wrong about that. But I do believe that that varying the number of justices is a tool that the founders intended to be a control on the courts, subject to public opinion. So FDR's court packing plan means a rebellion of public opinion.
Do you want to expand the number of justices?
Do I want to?
No, I'm wondering, I was trying to remember, was part of FDR's court packing plan?
Oh, it was to expand the number of justices.
From 9 to 15?
9 to 15 on the humanitarian grounds that they were elderly and working too hard, and we needed 6 new ones, and while we were at it, I'll appoint the 6 new ones. Now, there used to be the prevailing understanding used to be that had worked because one justice switched his vote on the California case, West Coast Hotel v. Parish, but the best evidence now, I think, is that Justice Owen had decided to do that earlier, before the court packing plan.
Yes.
What does Madison say, or what would Madison say about branches that disagree with each other? I can see, direct active opposition, such as California as a state, as opposed to the president's, the administration's immigration policies, which is today's news. And the passive one would be Brown, which was just benign neglect until the Civil Rights era.
Right. So in other words, when you say branches, you mean the national and state, national and state,
of power.
He says explicitly to Rohn that his preference is with the former, with the national, and I describe Madison as believing in a strong government of limited powers, but within those powers, Hamilton says this too in Federalist 23 and 31, that where there are powers, those powers are complete. Right. So it bears remembering that the whole project of the Constitution in Philadelphia was to repair an impotent national government. We can't even properly call a government in any sense. So there's a clear the whole thrust of the project is to establish adequate authority at the center. Now, authority within a limited scope, but still adequate to, as the circular said, adequate to the exigencies of the Union, I think.
Well, we're very glad you came, and thank you very much for the wisdom of what you're saying. Oh, no, there's more?
I know so little about the subject, I have to ask like simpleton questions, but which help me, where are your strongest disagreements with the way Madison thinks about the Constitution? That's my first question, or where you think he's really strongest on? And then where would this have any bearing regarding the very current situation that seems,
Yeah, I am least persuaded by the theory of constitutional change, except to say, in other words, that the bank, for example, could become constitutional, or that it could be settled as constitutional over time. I think there are real problems that are buried in that set of assumptions. Now, I don't have a better, I'm not sure I have a better solution than he does, but I think there are real problems. Where I'm most persuaded is what Professor Mansfield was saying with the gradual nature of politics for Madison over the way that politics conducts itself naturally, slowly over an extended territory, the way the requirement of the concurrence of at least 2 branches, perhaps a third in some cases, that are elected over different electoral rhythms and so forth. So the requirement of sustained majorities, I think, is quite important. And I think it's quite important today in that we view the failure to pass legislation as a failure of the system. When in fact, what would be a failure is if a persistent majority wanted something and didn't get it. But I can't think of a single case in American history where a truly persistent national majority wanted something and did not ultimately get it.
Andy.
Thank you for your thought-provoking paper and talk. I also wanted to ask you about the current moment that Republican forms in light of mass media, so radio, and television, the internet, and social media. So the notion of even something like the Electoral College with reference to being close enough to an elector in a community or physical setting, what you think Madison might have said about his Constitution in light of these differences, and what do you think?
So the just on one small point, I mean, I would say the Electoral College never quite works as intended. You could say it did in the first election, but it wasn't. That wasn't a controverted election. I think Madison would be alarmed by. I think there are two things here that both they're equally important. One is that he would be alarmed by the pace of politics, which is fueled by technology. And two is he would say, don't simply sit around and wring your hands over the way things used to be, because Madison his politics were very prudent in the sense of adapting to circumstance. So I think the biggest difference is that patience was a fact of life in Madison's time, right? Things just didn't happen quickly. So it wasn't a matter of, nobody had Amazon Prime, right? So it wasn't a matter of patience being a virtue. I think it is a matter of patience being a virtue today. Now, to end that answer on an optimistic note, I'm often asked, is there any hope for reclaiming this understanding of the Constitution? And civic education, in my mind, has really corrupted the meaning of the Constitution, right? It emphasizes, I'll be very brief here, but I often tell the story of when my middle son was 9, he came home, or whatever age fourth grade is, he comes home on Constitution Day, all proud to tell me we study the Constitution. I said, what'd you learn? He said, I learned you can't ask me for my homework. And I said, well, what's that about? And he said, well, I have a right to be secure in my documents. So we had to walk that back a few feet, starting with the fact that I was not the executive branch of government. But the rights mentality that we have today, that Professor Glendon talks about so eloquently, is a product, I would say, of civic education, substantially. So it seems to me a civic education can be influential in a bad way. It can be influential in a good way as well. So I do think there's something to what we do professionally.
I'm not sure about that. I mean, the power of miseducation is only equal to the power of education.
Well, it suggests there is some
stronger.
power to education.
Yes.
You mentioned the issue of the political system not representing the democratic will of the majority. And of course today, because we have so much public opinion polling, we have a much better idea of the extent to which the political system either represents or fails to represent the will of the people. And I've been reading books like the new book by Page and Gillens, or the book last fall by E.J. Dionne and Norm Ornstein, that place a very heavy emphasis on the fact that the congressional lack of activity shows a sharp distinction, a failure to represent the popular will. indeed, this is certainly illustrated by the current polling about how heavy majorities want action in various kinds of gun control, like an assault weapons ban, or raising the legal age to purchase, or background checks. So you mentioned this about 5 minutes ago, this gap.
Right.
So I'm wondering if you could say something more about that, and I'm wondering particularly what James Madison's view about this problem would have been.
Well, I think a Madisonian failure would be a failure to register the views of a settled long-term majority, right? So I'm not sure. I've not read Dion's book, but I think in Ornstein too, I think there's a tendency to expect that what is registered in public opinion polling now should be translated into policy, which is not Madison's position. So the second thing I would say about that is that on Madisonian assumptions, premises, one has to assume there are a limited number of discrete activities the national government undertakes, because otherwise what he calls the Republican principle can't operate, right? Because there are so many, you get one vote and your member of Congress gets $2,000 a year or whatever it is, and it's hard to spend your vote on any given one of those. Which brings me where I'm leading to is the issue of guns. I think there's a discrepancy in intensity there, right? That people who are opposed to further regulation of guns are really quite intensely opposed, and there are a lot of them, by the way. I don't buy the premise that this is the NRA's money at work, and I think you have a relatively only relatively apathetic majority that is probably not going to cast their ballots on that issue.
And one could say something about the democratizing effect of surveys as
Yes.
tending to reduce the sovereignty of elections, for example.
Yes, that's right, and creating perhaps a sense of entitlement to be agreed with
Yeah.
in those moments.
Sort of institutionalizing haste.
Yes.
Haste.
Yes,
Right.
I think that's right.
One more.
In your discussion of letting things play out in time, was Madison at all, did he read Burke? Was he at all influenced by Burke?
I really want him to have been, but the answer is not that I'm aware of. And Burke was a very complicated figure in America at the time because American politics by the early 1790s were largely the sort of polarizing issue of the day was the French Revolution. So I think the fact that Burke had defended the rights of the colonies had been largely forgotten by that time. But I've never found, I do think that Madison has a Burkean disposition. There's a wonderful exchange of letters in which Jefferson says that no law should last longer than a generation, and which is crazy in practice. And Madison says that the improvements that the dead have made on the earth form a charge against the living. So I think that disposition is there, but there's no evidence that I'm aware of that he ever read Burke or was influenced by him.
His arguments on the bank, as you recount them, would argue for an argument for prescription.
Yes, although there's also Burke saying he would, with constitutional change, he would reform in order to restore, or I'm not something close to those words. So constitutional reforms would have to be compatible with not only compatible but serve the initial sense of the instrument.
All right. Thanks very much, Greg. It's been wonderful.